What's up, guys? It is the Bad Wolf. Once again, we are here talking about right to prevail. Travel. All right. So, why is right to travel a real thing? Well, it's a real thing because by the Supreme Court, and so ruled upon already in the federal court and upheld by the Constitution, you have a certain number of rights. And if you watch my video on the Bill of Rights, it tells you in there that I think it's the ninth and the 10th that you have rights in common law. You have certain rights that are not enumerated, which means to be numbered. So if your right is not numbered there, they're saying you still have the right. The states do not have the ability to take away those rights. Or is it a privilege? No. Driving can be a privilege. Well, let me say this correctly. Driving, the word driving means to do it, operate commercially, which can be licensed. That's a privilege. A right is that you have the right to have a vehicle privately and operate on the roads as long as you're not speeding and doing anything illegal or illegally transporting people or except whatever it is. If it's illegal, it's illegal. But for those of us who can handle ourselves accordingly, like a non-belligerent non-combatant, we have the right. But the system is there to take away that right if you abuse it or don't know how to use it. All right. So this particular video is going to be about right to travel, and you're going to see here, but why is this information important? Why is this information fact? Well, it's fact because you're going to read court cases that have already been adjudicated on the Supreme Court and federal court levels. That is the superior law of the land. If you didn't know that, you know now. But see, you can waive those rights, which is what we do on the normal basis, and they kind of tricked us into doing so long ago to operate as one of them in the public. Ergo, if you're asking for a license or a permission or a privilege, then you're asking the king for that. Okay. Which means you're in their jurisdiction. It's no different than joining a membership of whatever else. You either are free as a national and a state citizen, a non-resident, a private citizen, or you're operating in some type of public or legal person capacity where you're operating in their jurisdiction. And both of those operate right on top of each other in the same geographical area. One's on paper, one's the actual land. Constitution, terra firma jurisdiction, paper, de facto maritime admiralty jurisdiction. Okay. And neither shall the twine be intertwined. You can only be in one or the other at the exact moment in time. You can switch between the two within a minute or 2 seconds, a thought. But if you're operating with a license, then you're in the public and you're a U.S. citizen. Now, most police officers know this. Well, I shouldn't say most. Most commanding officers and above, chief of police, they know this information, and they teach it to you just lightly. And yeah, I've got friends and family and neighbors who are police officers. They know exactly who and what I am. I've got people who are clients out there who are or who have become police officers that contact me for to know more. Okay, so the little charade is over. All right, people are waking up. But I'll be honest, we didn't know all this growing up. I didn't know this. I thought people who talk like me were against the country. But here's the thing, we're not. But are there? Yes, there are people against this country. And those are the sovereign people, sovereign citizens, though there's no actual legal classification for that. But there are people who think that they're above the law, and nobody's above the law but God. Okay, if you believe in God, if not, then there's nobody or anything above the law. So that also means that even though police officers want to say, well, you're not obeying the law, well, but you're not obeying the superior law. But we also did not go to school and learn constitutional law, private law, federal law. We didn't consume hell, we didn't consumer law, family law. There's lots of law out there. We didn't know that there was a superior one, which is the Supreme Court. Constitutional law is the supreme one. We're natural persons, and it applies to and over U.S. citizens. So without further ado, well, no, one more further ado. Don't forget to subscribe on Black Site 32 for the um, newsletter. Don't forget to hit that bell, like, subscribe here, and also join me on my new channel, which is the Badwolf Media channel. All right. We're trying to get the numbers up over there, but we're going to start talking about all the stuff going on, and you're going to hear it right from the wolf. You guys want to know how I really think about some things? I just hope that some of you guys who join me on that channel don't, not like my viewpoints and then, unsubscribe over here. Let's all be friends. No, really what it is, I have old school perspectives, but I also live in the new world, so I get it. So we're gonna break down a lot of these things. And we're gonna try to get some people back on track. Some people don't want any guidance or understanding of deeper things. We're gonna cover everything from relationships to UFOs to spirits to food to health, whatever it is. We're gonna drop it all in that channel. So join me over there. Trust me, it will be fire. I rarely recommend anything unless it's impressive to me. And so I'm not gonna I guess I am tooting my own horn. Um, but yeah, it's gonna be good. So now, without further ado, and as always, guys, if you sorry, just checking some emails, never stops. Um, send this the remaining four. What remaining four? Debt discharge. It's gonna be good. Like I said, it's gonna be good over there. Let me just get this email sent because people just have no patience. Okay, so that once again, this is an email where he said he didn't get him, so whatever. I guess I won't blame him. Might be a system error. Anyway, boom. Okay, so let's get to the video, and I'll break some of this down as we go through. Shout out to Law Books, and let's go.
Now comes the accused, appearing specially and not generally or voluntarily, but under threat of arrest if he failed to do so, with this brief and supportive notice for dismissal for lack of jurisdiction, stating as follows. Argument. If ever a judge understood the public's right to use the public roads, it was Justice Tolman of the Supreme Court of the State of Washington. Justice Tolman stated, complete freedom of the highways is so old and well established a blessing that we have forgotten the days of the robber barons and toll roads, and yet, under an act like this, arbitrarily administered, the highways may be completely monopolized. If, through lack of interest, the people submit, then they may look to see the most sacred of their liberties taken from them one, by more or less rapid encroachment. Robertson v. Department of Public Works, 180 Wash 133, 147. The words of Justice Tolman ring most prophetically in the ears of citizens throughout the country today, as the use of the public roads has been monopolized by the very entity which has been empowered to stand guard over our freedoms, i.e., that of state government. Rights. The most sacred of liberties of which Justice Tolman spoke was personal liberty. The definition of personal liberty is: personal liberty, or the right to enjoyment of life and liberty, is one of the fundamental or natural rights, which has been protected by its inclusion as a guarantee in the various constitutions, which is not derived from, or dependent on, the U.S. Constitution, which may not be submitted to a vote and may not depend on the outcome of an election. It is one of the most sacred and valuable rights, as sacred as the right to private property, and is regarded as inalienable. 16 CJS, Constitutional Law, Sect. .202, page
Consti-
987.
Constitutional law.
This concept is further amplified by the definition of personal liberty. Personal liberty largely consists of the right of locomotion to go where and when one pleases, only so far restrained as the rights of others may make it necessary for the welfare of all other citizens. The right of the citizen to travel upon the public highways and to transport his property thereon, by horse-drawn carriage, wagon, or automobile, is not a mere privilege which may be permitted or prohibited at will, but the common right which he has under his right to life, liberty, and the pursuit of happiness. Under this constitutional guarantee one may, therefore, under normal conditions, travel at his inclination along the public highways or in public places, and while conducting himself in an orderly and decent manner, neither interfering with nor disturbing another's rights, he will be protected, not only in his person, but in his safe conduct. 2 A.M. Jure. First, Constitutional Law, Sect. .329, page 1135. And further. Personal liberty consists of the power of locomotion, of changing situations, of removing one's person to whatever place one's inclination may direct, without imprisonment or restraint unless by due process of law. Bouvier's Law Dictionary, 1914 edition, Black's Law Dictionary, 5th edition, Blackstone's Commentary 134, Hare, Constitution __PG. 777. Justice Tolman was concerned about the state prohibiting the citizen from the most sacred of his liberties, the right of movement, the right of moving one's self from place to place without threat of imprisonment, the right to use the public roads in the ordinary course of life. When the state allows the formation of a corporation, it may control its creation by establishing guidelines, statutes, for its operation, charters. Corporations who use the roads in the course of business do not use the roads in the ordinary course of life. There is a difference between a corporation and an individual. The United States Supreme Court has stated, "We are of the opinion that there is a clear distinction in this particular between an individual and a corporation, and that the latter has no right to refuse to submit its books and papers for examination on the suit of the state. The individual may stand upon his constitutional rights as a citizen. He is entitled to carry on his private business in his own way. His power to it may tend to incriminate him. He owes no such duty to the state, since he receives nothing therefrom, beyond the protection of his life, liberty, and property. His rights are such as the law of the land long ante."
All right. Did you guys hear that? They say we do not owe them anything, but they owe us everything. We owe them nothing unless we operate as one of them willingly. We waive our rights to go from the private side in the moment thereof and become public. They are the ones who are supposed to, in all actuality, abide by all of these signs out there in the world. Of course, it doesn't mean you can say, oh, I'm going to ignore somebody's private sign or private property. No, I'm not saying that. What I'm saying is that like these signs were put up for them to abide by, and anybody who's doing commercial activities. Now, if you've gotten any of my packages, you know that in some of them, it does say that within moderate reasoning that, people can travel with the speed of traffic, sometimes a little bit faster, a little bit slower, but in general, speeding recklessly and endangering people and not going with the flow of traffic is in fact a violation of public safety. But in general, if the roads are called public, that means anybody can use them, whether they're public or private. People who have responsibilities to the public are public officers or public officials or public trustees. They're held to protect and provide for the public, which are their own members, and the private who come to them, which would be nationals. So they owe us. We don't owe them unless we're operating as them. You guys have to know what's going on. Let's keep going.
antecedent to the organization of the state, and can only be taken from him by due process of law, and in accordance with the Constitution.
Yes, sir.
Among his rights are the refusal to incriminate himself, and the immunity of himself and his property from arrest or seizure except under warrant of law. He owes nothing to the public so long as he does not trespass upon their rights.
Exactly.
Upon the other hand, the corporation is a creature of the state. It is presumed to be incorporated for the benefit of the public.
Oh,
It
hold
receives
on.
certain special privileges and franchises,
Hold on.
and holds them.
I made a video on that. It said it is presumed to be incorporated for the benefit of the public. I have been looking for that line for a while, and I wish I would have found that before I made my last video, because we were trying to find out what the structure is of the states. So let me go back and look at that. Upon the other hand, the corporation is a creature of the state. It is presumed to be incorporated for the benefit of the public. So it doesn't exactly say the states. We know the municipalities are definitely corporate. What the state of is what I was looking for. But once again, if all of them are corporations and the states themselves are a type of business entity, it is my belief that they are in fact incorporations. But we can't find that anywhere straight out. So let's keep going, see what it says. Maybe we'll get lucky in here.
Them subject to the laws of the state and the limitations of its charter. Its rights to act as a corporation are only preserved to it so long as it obeys the laws of its creation. Creation. There is a reserved right in the legislature to investigate its contracts and find out whether it has exceeded its powers. It would be a strange anomaly to hold that the state, having chartered a corporation to make use of certain franchises, could not in exercise of its sovereignty inquire how those franchises had been employed, and whether they had been abused, and demand the production of corporate books and papers for that purpose. Hale v. Hinkle, 201 U.S. 43, 74-75. Corporations engaged in mercantile equity fall under the purview of the state's admiralty jurisdiction, and the public at large.
So they're telling you the state has admiralty jurisdiction. That is laws and rules of the water. But the state itself, what is its taxable structure? What is its actual business structure? Everything keeps saying it's either a corporation or it's incorporated all around it, but can't find anything where it actually says the state has itself is a corporation. You can't find anything on what it is. It says it's a state. So they literally went to the government and got an EIN underneath these names. But unless we can see that document to know how it's organized, but remember, corporations usually have shareholders, board members, and that's what the states have. But they could be a different type of business. Like I said, even for mine, I'm an unincorporated association. But nonetheless, that's just some stuff I'm working on the side. Let's get back to the main focus here. I apologize.
Large must be protected from their activities, as they, the corporations, are engaged in business for profit.
There it is.
Based upon the fundamental ground that the sovereign state has the plenary control of the streets and highways in the exercise of its police power, see police power, infra. May absolutely prohibit the use of the streets as a place for the prosecution of a private business for gain. They all recognize the fundamental distinction between the ordinary right of the citizen to use the streets in the usual way and the use of the streets as a place of business or a main instrumentality of business for private gain. The former is a common right, the latter is an extraordinary use. As to the former, the legislative power is confined to regulation; as to the latter, it is plenary and extends even to absolute prohibition. since the use of the streets by a common carrier in the prosecution of its business as such is not a right but a mere license of privilege. Hadfield versus London, 98 Wash 516. It will be necessary to review early cases and legal authority in order to reach a lawfully correct theory dealing with this right or privilege. We will attempt to reach a sound conclusion as to what is a right to use the road and what is a privilege to use the road. Once reaching this determination, we shall then apply those positions to modern case decision. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Miranda versus Arizona, 384 U.S. 436, 491. And the claim and exercise of a constitutional right cannot be converted into a crime. Miller versus U.S., 230 F. 486, 489. And there can be no sanction or penalty imposed upon one because of this exercise of constitutional rights. Sneerer versus Cullen, 481 F. 946. Streets and highways are established and maintained for the purpose of travel and transportation by the public. Such travel may be for business or pleasure. The use of the highways for the purpose of travel and transportation is not a mere privilege, but a common and fundamental right of which the public and the individual cannot be rightfully deprived.
There it is.
Chicago Motor Coach versus Chicago, 169 in E22, Ligure versus Chicago, 28 Northeast 934, Boone versus Clark, 214 SSW 607, 25 AM, jure. First, Highways Sect. .163. And the right of the citizen to travel upon the public highways and to transport his property thereon, either by horse-drawn carriage or by automobile, is not a mere privilege which a city can prohibit or permit at will, but a common right which he has under the right to life, liberty, and the pursuit of happiness. Thompson versus Smith, 154 SE 579. So we can see that a citizen has a right to travel upon the public highways by automobile and the citizen cannot be rightfully deprived of his liberty.
Facts.
So where does the misconception that the use of the public road is always and only a privilege come from? For while a citizen has the right to travel upon the public highways and to transport his property thereon, that right does not extend to the use of the highways either in whole or in part, as a place for private gain. For the latter purpose, no person has a vested right to use the highways of the state, but is a privilege or a license which the legislature may grant or withhold at its discretion. State versus Johnson, 243 p. 1073, Cummins versus Holmes, 155 p. 171, Packard versus Banton, 44s.ct.
So what they're saying here, the citizen has a right to travel upon the public highways by automobile, means private, doesn't say motor vehicle, and the citizen cannot be rightfully deprived of his properties. So where does this come from? The right does not extend to the use of the highways, either in whole or in part, as a place for private gain. So they're saying you can use it, but if you're going to use the roads to make private money, that's a no-no. This is like the only rebuttal they try to have. Well, State versus Johnson said you can't be on the roads and using what they're saying here is that you can't use it for private gain. You have to be commercial because you're using the roads that the American people have paid for to make money off of them while utilizing and damaging the road. Ergo, you have to pay a tax and be licensed to do whatever you're doing for your own gain on the public side. Or even if you're going to do it privately, you then have to be licensed and pay taxes on it. Because we, the American people, pay for those roads, so we want to be paid. You're going to use our stuff to make money off of us? Pay us for the road, the use. We put those there. But they can't tell people you can't use the roads for private reasons, for pleasure, or to go from A to B. Let's keep going. You see what I'm saying?
CT 256, Hadfield versus London, 98 Wash 516. Here the court held that
that Hadfield versus London, 98 Wash 516. These are the court cases where they battle it out. One of these two people, Hadfield or London, Packard versus Banton, Cummings versus Holmes, State versus Johnson, somebody in here were arguing you can't use the road for private gain, or you can use it for that, or I can do right to travel. So these are the cases that have already been settled and adjudicated. These are now facts. This is now law. But this is what they call case law. But the lower courts don't have to use case law because they have their own set. So they can ignore you when you're talking about these things because this is constitutional jurisdiction and you're talking about state. But constitutional jurisdiction has power over state, but they cannot interfere in a private agreement unless you raise the question that you are invoking constitutional law, private law, or whatever else you're using. At the time of this matter, I was not in public capacity as a U.S. citizen. My vehicle is private, et cetera, et cetera. All right, so let's keep going.
a citizen has the right to travel upon the public highways, but that he did not have the right to conduct business upon the highways.
Because business is their word. You're conducting either a trade or business on these government-built roads, paid for, though, by the American people, maintained by them. And if you're doing business, you're making money off of them. You're doing your own private little Uber or whatever else, you're making money on the roads, well, you're supposed to pay us for that. You can't do that, but you can do right to travel. Now, some people would say, well, they're just talking about you have the ability to use the roads. Well, they don't need to say that. Everybody knows you have the right to use the roads. They didn't think they needed to specifically, in some cases, operate right to travel privately. So a lot of them construe this to say, well, they're just saying the citizen has the right to travel upon the public highways. Why would we not have the right? They're roads and they're public. All right, but let's see what else they have to say. Let's keep going.
Highways. On this point of law, all authorities are unanimous. Heretofore the court has held, and we think correctly, that while a citizen has the right to travel upon the public highways and to transport his property thereon, that right does not extend to the use of the highways either in whole or in part, as a place of business for private gain. Willis v. Buck, 263 p. L. 982, Barney v. Board of Railroad Commissioners, 17 p.2 d. 82. And the right of the citizen to travel upon the highway and to transport his property thereon, in the ordinary course of life and business, differs radically and obviously from that of one who makes the highway his place of business for private gain in the running of a stagecoach or omnibus. State v. City of Spokane, 186 p. 864. What is this right of the citizen which differs so radically and obviously from one who uses the highway as a place of business? Who better to enlighten us than Justice Tolman of the Supreme Court of Washington State? In State v. City of Spokane, Supra, the court also noted a very radical and obvious difference, but went on to explain just what the difference is. The former is the usual and ordinary right of the citizen, a common right to all, while the latter is special, unusual, and extraordinary. And This distinction, elementary and fundamental in character, is recognized by all the authorities. State versus City of Spokane, Supra. This position does not hang precariously upon only a few cases, but has been proclaimed by an impressive array of cases ranging from the state courts to the federal courts. The right of the citizen to travel upon the highway and to transport his property thereon in the ordinary course of life and business differs radically and obviously from that of one who makes the highway his place of business and uses it for private gain in the running of a stagecoach or omnibus. The former is the usual and ordinary right of the citizen, a right common to all, while the latter is special, unusual, and extraordinary. Ex parte Dickey vs. and. The right of the Thompson vs. Smith, Supra, Teche Lines vs. Danforth, Mississippi, 12S.2d 784. There is no dissent among various authorities as to this position. CAM. Jure. First, Constable Law, 329 and corresponding AM. Jure. Second, dot. Personal liberty or the right to enjoyment of life and liberty is one of the fundamental or natural rights, which has been protected by its inclusion as a guarantee in the various constitutions, which is not derived from nor dependent on the U.S. Constitution. It is one of the most sacred and valuable rights, remember the words of Justice Tolman, Supra. As sacred as the right to private property, and is regarded as inalienable. 16 CJS Constable Law, Sect.202, page 987. As we can see, the distinction between a right to use the public roads and a privilege to use the public roads is drawn upon the line of using the road as a place of business, and the various state courts have held so. But what have the U.S. courts held on this point? First, it is well-established law that the highways of the state are public property, and their primary and preferred use is for private purposes, and that their use for purposes of gain is special and extraordinary, which, generally at least, the legislature may prohibit or condition as it sees fit. Stevenson vs. Rinford, 287 U.S. So what? Traveling upon and transporting one's property upon the public roads, which is our right, and using the public roads as a place of business or a main instrumentality of business, which is a privilege. The roads are constructed and maintained at public expense, and no person therefore can insist that he has, or may acquire, a vested right to their use in carrying on a commercial business. Ex parte Sterling, 53 SW.2d. When the public highways are made the place of business, the state has a right to regulate their use in the interest of safety and convenience of the public as well as the preservation of the highways.
That's why if you're doing anything commercial or for profit, using the roads themselves to make a gain, they are going to, for public safety, make sure that you're doing it fair, right, just. Everybody's getting paid. But you can use them privately.
Highways. Thompson vs. Smith, Supra. The state's right to regulate such use is based upon the nature of the business and the use of the highways in connection therewith. Ibid. We know of no inherent right in one to use the highways for commercial purposes. The highways are primarily for the use of the public, and in the interest of the public, the state may prohibit or regulate the use of the highways for gain. Robertson vs. Department of Public Works, Supra. There should be considerable authority on a subject as important as this deprivation of the liberty of the individual using the roads in the ordinary course of life and business. However, it should be noted that extensive research has not turned up one case or authority acknowledging the state's power to convert the individual's right to travel upon the public roads into a privilege. Therefore, it is concluded that the citizen does have a right to travel and transport his property upon the public highways and roads, and the exercise of this right is not a privilege. Definitions. In order to understand the correct application of the statute in question, we must first define the terms used in connection with this point of law. As will be shown, many terms used today do not, in their legal context, mean what we assume they mean, thus resulting in the misapplication of statutes in the instant case. Automobile and motor vehicle.
Let's go.
There is a clear distinction between an automobile and a motor vehicle.
So this is why a lot of people put the camera on me. Yeah. So this is why a lot of people will go, "Oh, Wolf, that's just semantics." No, it's because you're stupid. Oh, the wolf got jazzy. There's a difference between stupid and ignorance, okay? And in this case, people go, "But that's just semantics." You have to understand that when you're dealing with these things, you think you understand because of how you feel about a word being used, that it means what you think it does. But in reality, if you look up the same word in Black Law's dictionary, which is the legal source of their maritime admiralty jurisdiction under the UCC, or in conjunction with the UCC, we'll say, and America's Webster dictionary, the same word is going to have different definitions because one's America, Constitution, and this one is Black laws, which is maritime admiralty law, political, and in bed with the UCC. So, depending on what we look at the vehicle. Okay, so that's a UFO. Just work with me. Whoever owns this gets to define it. This is how the government works. This is how the law works. Whoever is the owner of the physical body, the material, the object, the entity, or whatever else can define it. And when you define it, that is what it is. So one of the reasons why a lot of people years ago couldn't find a lot of information on UFOs is because UFO is a slang term created by the public, unidentified flying object. The government calls it a UAP, unidentified aerial phenomena. Because in their jurisdiction, that's what they name it, not in the public. Then there's the public name for it. So from the public to the private, if this is your car, a police officer is trained to look at this as a motor vehicle. So he calls it such. But does he own it? No. But if you have your name, your legal name, registered to them for as a voter, et cetera, et cetera, you've proven to them with the piece of mail with your name in all caps, the legal entity, as a resident or a resident, and then that resident name, which is can be found in their database, is the owner of the vehicle. The legal person then owns it, and they administer jurisdiction over the residents and legal persons that they created or that were brought to them and then registered. So then that car is a motor vehicle because you went and got the plates on it. You got the license. The state then converted, which they're not supposed to do, a right and a liberty and a freedom into a privilege and charged for it. They are not supposed to do that to regular people, only to people who are going to be a part of the public and who hold public office. If you own this vehicle and it's private and you put it in a private trust, private name, not your first, middle, or last name, something, a private name, something made up, had some numbers and whatever else in there, not underneath any part of your name, not first, middle, or last. You put it in a trust. Now it's owned privately or foreign. Can't tax it, can't tow it, can't touch it unless you're doing something criminal or they get a warrant. That's how it works. And this then would be an automobile. This is a motor vehicle, commercial use, licensed, registered, recorded, private. You get me? Yeah, cool. So the reason why people don't understand this is because they don't go to school for any of this. This is what they call the legal level or legal style. Most people don't do this. There's a reason why I've been beating lawyers and judges and attorneys and going toe to toe with legal departments. There's a reason why they ask me to join them. Because when you're stupid smart and you can understand all this and you're self-taught, which most of mine is, then they're like, oh, we would love to have you on our side, which is what the judge told me. Mr. Lovett, we would love to have you on our side. You're a, you know. But anyway, let's get back to it. Roll it.
Vehicle. An automobile has been defined as. The word automobile connotes a pleasure vehicle designed for the transportation of persons on highways. American Mutual Liability Insurance Company versus Chaput.
So apparently, American Mutual Liability Insurance Company went after Chaput, and they were like, well, what is your definition legally of an automobile? I said, well, this connotes pleasure. It's a pleasure vehicle, which means for private. Pleasure is private. Designed for the transportation of persons on the highways. So it's private. Okay, let's keep going.
Chaput, 68.2d 118, 100, while the distinction is made clear between the two as the courts have stated. A motor vehicle or automobile for hire is a motor vehicle, other than an automobile stage, used for the transportation of persons for which remuneration is received. International Motor Transport.
So once again, you can see these insurance companies, these international motor companies, all going at, and here it's Seattle, so they went after the city. So apparently the city and this motor company, well, so it was probably the International Motor Transit Company was like, hey, you can't tax us. We're not this type of whatever. And the city of Seattle was like, oh yeah, you are. We can tax you. So they went to court over it. And they used this and defined what it is: a motor vehicle or automobile for hire. Now, notice what they said here. Notice how I said an automobile is private, but what are the key words? Wolf, I thought you just said that automobile is private. And that's for pleasure. Yes, but look what they did here. They said a motor vehicle, which we already know is for profit in the public, commercial, or an automobile, which, okay, so automobile is private, not for profit, right? Yes. But look at the next words. For a hire. That's commercial. When they want to hire you, that's commercial. Hire means commercial. So they said if you have a private vehicle, not for profit, but now it's for hire, so it is for profit now, it is a motor vehicle. It has been brought down from its high place and turned into nothing more than a motor vehicle in that moment while you're doing that. You see how it works? You allowed your vehicle, your private automobile, to be transmuted by hiring, doing commercial things. You turn it into a motor vehicle, no matter what you got going on.
Transit Company versus Seattle, 251p. 120. The term motor vehicle is different and broader than the word automobile. City of Dayton versus DeBras, 20. The distinction is made very clear in Title 18 U.S.C. 31.
Okay, so all those naysayers, let's see what under title, so federal law, Title 18 U.S.C. 31. Let's see what the government has to say. What does the federal law say on it? Because they're the superior law of the land. What do they say? Don't take my word for it.
31. Motor vehicle means every description or other contrivance propelled or drawn by mechanical power and used for commercial
purposes. For profit, money, for hire.
Purposes on the highways in the transportation of passengers and property. Used for commercial purposes means the carriage of persons or property for any fare, fee, rate, charge or other considerations, or directly or indirectly in connection with any business.
Once again, business, they own the word. There it is.
Business or other undertaking intended for profit.
Intended is a key word there, but for profit.
Profit. Clearly, An automobile is private property.
There you go. So there is a distinction in the words. It's not just legally. It's not just semantics. These are facts. Facts, son.
Property in use for private purposes, while a motor vehicle is a machine which may be used upon the highways for trade, commerce, or hire. Travel. The term travel is a significant term and is defined as: the term travel and traveler are usually construed in their broad and general sense, so as to include all those who rightfully use the highways viatically, when being reimbursed for expenses, and who have occasion to pass over them for the purpose of business, convenience, or pleasure.
So you can do all of these things. That's what the word travel means. You can do all of them. Travel doesn't mean just from A to B. Literally saying it can be for business, convenience, or pleasure. Because you can do your private business, convenience, or pleasure. Nowhere in here does it say for commercial. That's what a motor vehicle is for.
Pleasure. 25 a.m. Jure. Traveler, one who passes from place to place, whether for pleasure, instruction, business, or health. Lockett versus State, 47. Travel to journey or to pass through or over, as a country district, road, etc. To go from one place to another, whether on foot, or horseback, or in any conveyance as a train, an automobile, carriage, ship, or aircraft, make a journey. Century. Therefore, the term travel or traveler refers to one who uses a conveyance to go from one place to another, and included all those who use the highways as a matter of right. Notice that in all these definitions, the phrase for hire never occurs. This term travel or traveler implies, by definition, one who uses the road as a means to move from one place to another.
And not for profit. That's why it's a right.
Another. Therefore, one who uses the road in the ordinary course of life and business for the purpose of travel and transportation is a traveler. Driver. The term driver, in contradistinction to traveler, is defined as: driver, one employed in conducting a coach, carriage, wagon, or other vehicle.
That's why they call it a driver's license. So Bouvier's Law, Dictionary, 1914 edition, page 940 says, driver's one employed. This is a commercial term. In conducting is a commercial term. A coach, commercial, carriage, go either way, wagon could go either way, or other vehicle. One employed. So the whole modifier here is the word employed in conducting. This connotes commercial.
TM, welcome to U.S. Law Books. USLawbooks.com. Driver, one employed in conducting a coach, carriage, wagon, or other vehicle. Notice that this definition includes one who is employed in conducting a vehicle. It should be self-evident that this individual could not be traveling on a journey, but is using the road as a place of business.
Which they said earlier means commerce, and you can't do it without being licensed.
Business. Operator. Today we assume that a traveler is a driver, and a driver is an operator. However, this is not the case. It will be observed from the language of the ordinance that a distinction is to be drawn between the terms operator and driver. The operator of the service car being the person who is licensed to have the car on the streets in the business of carrying passengers for hire, while the driver is the one who actually drives the car. However, in the actual prosecution of business, it was possible for the same person to be both operator and driver. Newbill vs. Union Indemnity Company, 60 SE.2d 658. To further clarify the definition of an operator, the court observed that this was a vehicle for hire and that it was in the business of carrying passengers. This definition would seem to describe a person who is using the road as a place of business, or in other words, a person engaged in the privilege of using the road for gain. This definition, then, is a further clarification of the distinction mentioned earlier, and therefore, traveling upon and transporting one's property upon the public roads as a matter of right meets the definition of a traveler. Using the road as a place of business as a matter of privilege meets the definition of a driver or an operator or both. Traffic. Having defined the terms automobile, motor vehicle, traveler, driver, and operator, the next term to define is traffic. Traffic thereon is to some extent destructive, therefore, the prevention of unnecessary duplication of auto transportation service will lengthen the life of the highways or reduce the cost of maintenance. The revenue derived by the state will also tend toward the public welfare by producing at the expense of those operating for private gain some small part of the cost of repairing the wear. Northern Pacific RR Company. Note, in the above, Justice Tolman expounded upon the key of raising revenue by taxing the privilege to use the public roads at the expense of those operating for gain.
So why would they do this? Because one, the state, the county, everybody gets their share. Why would they allow us to slide into this whole charade of being public officers? Because they can make even more money. You know how little money they would make for their back pockets, especially, and then donate some of that money to their general trust to then build more streets. And don't get me wrong, some of it does go to maintenance, but but the whole thing here is they're making the money. And really, they're only supposed to be getting the money from food and mercantile things you buy in the area. But they created it a long time ago. There was a time where there was no tax for a vehicle or for using the roads. There was no driving. I mean, they were paid and they were good. And then you buy stuff in the area, they take that money and use it to go towards that. Then they figured out, hey, let's tax all these vehicles for using the road. Let's tax them. Well, let's let everybody come in if they choose, if they're not smart enough to know how to not to be public. So they can double dip, make more money, grow bigger, faster, stronger.
Gain. In this case, the word traffic is used in conjunction with the unnecessary auto transportation service, or in other words, vehicles for hire. The word traffic is another word which is to be strictly construed to the conducting of business. Traffic, commerce, trade.
Did you know that? Did you know that traffic means commerce, trade, sale or exchange of merchandise? The word merchan, water, Atlantean laws, merman, mermaid.
Trade, sale or exchange of merchandise, bills, money, or the like. The passing of goods and commodities from one person to another for an equivalent in goods or money.
That is the legal definition in Bouvier's Law Dictionary of the word traffic.
Bouvier's Law Dictionary, 19. Here again.
People are out here talking about they know what it is. You're not the law department. I've been studying the law department on the law level, the legal style of these things for 30 plus years. I've been fighting with these people, and at 19, I won my first court case against the city prosecutor, county prosecutor, my bad. And which then in turn beat the judge. because I overstand this information. You have to break down the definition of these words.
Again, notice that this definition refers to one conducting business. No mention is made of one who is traveling in his automobile. This definition is of one who is engaged in the passing of a commodity or goods in exchange for money, i.e., vehicles for hire. Furthermore, the word traffic and travel must have different meanings which the courts recognize. The difference is recognized in ex parte dicey, supra. In addition to this, cabs, hackney coaches, omnibuses, taxicabs, and hacks, when unnecessarily numerous, interfere with the ordinary traffic and travel and obstruct them. The court, by using both terms, signified its recognition of a distinction between the two. But what was the distinction? We have already defined both terms, but to clear up any doubt. The word traffic is manifestly used here in secondary sense, and has reference to the business of transportation rather than to its primary meaning of interchange of commodities. Allen v. City of Bellingham, 163 p. 18. Here the Supreme Court of the State of Washington has defined the word traffic, in either its primary or secondary sense, in reference to business, and not to mere travel. So it is clear that the term traffic is.
So the Supreme Court in Washington, which then means all the Supreme Courts have to agree on this, that the word traffic means business. That means public, commerce, commercial. That's it. They are the supreme law, Supreme Court. That's why this is law. These things are law. They've been decided, adjudicated.
Is business related and therefore, it is a privilege. The net result being that traffic is.
It's a privilege in the understanding that they are granting you the right to be a member of theirs and to do this under their sanction and jurisdiction. They don't own the area, but if you're in that area, you can operate with their protections, their penalties. As a member of theirs, but you do not have to. You still have to abide by the rights of the road, safety, the public.
Brought under the police power of the legislature. The term has no application to one who is not using the roads as a place of business. License. It seems only proper to define the word license, as the definition of this word will be extremely important in understanding the statutes as they are properly applied. The permission, by competent authority to do an act which without permission, would be illegal, a trespass, or a tort.
Sue 'em.
People v. Henderson, 218 N. Leave to do a thing which licensor could prevent. Western Electric Company v. Packant. In order for these two definitions to apply in this case, the state would have to take up the position that the exercise of a constitutional right to use the public roads in the ordinary course of life and business is illegal, a trespass, or a tort, which the state could then regulate or prevent. This position, however, would raise magnitudinous constitutional questions, as this position would be diametrically opposed to fundamental constitutional law.
So they can't
See
do it.
conversion of a right to a crime, infra. In the instant case, the proper definition of a license is a permit, granted by an appropriate governmental body, generally for consideration, to a person, firm, or corporation, to pursue some occupation or.
So that means any of these things can have a permit or a license. A person, a firm, a corporation, all of these can be treated and regarded as the same thing. They all have the rights to have a license and permit, all of them. Some gem drops in there.
Or to carry on some business which is subject to regulation under the police power. Rosenblatt vs. Cal. This definition would fall more in line with the privilege of carrying on business on the streets. Most people tend to think that licensing is imposed by the state for the purpose of raising revenue, yet there may well be more subtle reasons contemplated. For when one seeks permission from someone to do something, he invokes the jurisdiction of the licensor, which, in this case, is the state.
There you go.
In essence, the licensee may well be seeking to be regulated by the licensor. A license fee is a charge made primarily for regulation, with the fee to cover costs and expenses of supervision or regulation. State versus Jackson, the fee is the price, the regulation or control of the licensee is the real aim of the legislation.
There you go.
Are these licenses really used to fund legitimate government, or are they nothing more than a subtle introduction of police power into every facet of our lives? Have our enforcement agencies been diverted from crime prevention, perhaps through no fault of their own, instead now busying themselves as they check our papers to see that all are properly endorsed by the state? How much longer will it be before we are forced to get a license for our lawnmowers, or before our wives will need a license for her blender or mixer? They all have motors on them, and the state can always use the revenue. Police power. The confusion of the police power with the power of taxation usually arises in cases where the police power has affixed a penalty to a certain act, or where it requires licenses to be obtained and a certain sum be paid for certain occupations. The power used in the instant case cannot, however, be the power of taxation, since an attempt to levy a tax upon a right would be open to constitutional objection. See taxing power, infra. Each law relating to the use of police power must ask 3 questions. 1. Is there threatened danger? 2. Does a regulation involve a constitutional right? 3. Is this regulation reasonable? People versus Smith. When applying these 3 questions to the statute in question, some very important issues emerge. First, is there a threatened danger in the individual using his automobile on the public highways, in the ordinary course of life and business? The answer is no. There is nothing inherently dangerous in the use of an automobile when it is carefully managed. Their guidance, speed, and noise are subject to a quick and easy control. Under a competent and considerate manager, it is as harmless on the road as a horse and buggy. It is the manner of managing the automobile, and that alone, which threatens the safety of the public. The ability to stop quickly and to respond quickly to guidance would seem to make the automobile one of the least dangerous conveyances. See Yale Law Journal, December, 1905. The automobile is not inherently dangerous. Cohens vs. Meadow, 89 SE 876, Blair vs. Broadmoor, 93 SE 532. To deprive all persons of the right to use the road in the ordinary course of life and business, because one might, in the future, become dangerous, would be a deprivation not only of the right to travel, but also the right to due process. See due process, infra. Next, does the regulation involve a constitutional right? This question has already been addressed and answered in this brief, and need not be reinforced other than to remind this court that this citizen does have the right to travel upon the public highway by automobile in the ordinary course of life and business. It can therefore be concluded that this regulation does involve a constitutional right. The third question is the most important in this case. Is this regulation reasonable? The answer is no. It will be shown later in regulation, infra, that this licensing statute is oppressive and could be effectively administered by less oppressive means. Although the 14th Amendment does not interfere with the proper exercise of the police power, in accordance with the general principle that the power must be exercised so as not to invade unreasonably the rights guaranteed by the United States Constitution, it is established beyond question that every state power, including the police power, is limited by the 14th Amendment and others, and by the inhibitions there imposed. Moreover, the ultimate test of the propriety of police power regulations must be found in the 14th Amendment, since it operates to limit the field of the police power to the extent of preventing the enforcement of statutes in denial of rights that the amendment protects. See Parks v. State, 64 NE 682. With regard particularly to the U.S. Constitution, it is elementary that a right secured or protected by that document cannot be overthrown or impaired by any state police authority. Connolly v. Union Sewer Pipe Company, 100. The police power of the state must be exercised in subordination to the provisions of the U.S. Constitution.
Did you hear that? The police power of the state, so the police and the state, must be exercised so they have the right to do it in subordination to the provisions of the United States Constitution. This has already been established. When you exert your constitutional rights and you haven't done any wrong, they have to all back down. Period.
Constitution. Bakahanan versus Wanlei. It is well settled that the constitutional rights protected from invasion by the police power include rights safeguarded both by express and implied prohibitions in the constitutions. Tisch versus Osborne. As a rule, fundamental limitations of regulations under the police power are found in the spirit of the constitutions, not in the letter, although they are just as efficient as if.
So they're saying, look, this makes so much sense that even though it's not written specifically and articulated, that it's there. We all know it. We all have it. It was there and being used before the rest of these states had all these other laws in place.
As if expressed in the clearest language. Mellows, as it applies in the instant case, the language of the Fifth Amendment is clear. No person shall be deprived of life, liberty, or property without due process of law. As has been shown, the courts at all levels have firmly established an absolute right to travel. In the instant case, the state, by applying commercial statutes to all entities, natural and artificial persons alike, has deprived this free and natural person of the right of liberty, without cause and without due process of law. Due process. The essential elements of due process of law are notice and the opportunity to defend. Simon versus Kraft, 182 U.S. 427. Yet, not one individual has been given notice of the loss of his/her right, let alone before signing the license, contract. Nor was the citizen given any opportunity to defend against the loss of his/her right to travel, by automobile, on the highways, in the ordinary course of life and business. This amounts to an arbitrary deprivation of liberty. There should be no arbitrary deprivation of life or liberty. Barber versus Connolly, 113 U.S. 27, 31, Yiqua versus Hopkins, 118 U.S. 356. And the right to travel is part of the liberty of which a citizen cannot deprived without due process of law under the Fifth Amendment. This right was emerging as early as the Magna Carta. Kent versus Dulles, 357 U.S. 116, 1958. The focal point of this question of police power and due process must balance upon the point of making the public highways a safe place for the public to travel. If a man travels in a manner that creates actual damage, an action would lie, civilly, for recovery of damages. The state could then also proceed against the individual to deprive him of his right to use the public highways, for cause. This process would fulfill the due process requirements of the Fifth Amendment while at the same time ensuring that rights guaranteed by the U.S. Constitution and the state constitutions would be protected. But unless or until harm or damage, a crime, is committed, there is no cause for interference in the private affairs or actions of a citizen. One of the most famous and perhaps the most quoted definitions of due process of law is that of Daniel Webster in his Dartmouth College case, 4 Wheat 518, in which he declared that by due process is meant a law which hears before it condemns, which proceeds upon inquiry, and renders judgment only after trial. See also State versus Strasburg, 110 p. 1020, Dennis versus Moses, 52 p. 333. Somewhat similar is the statement that is a rule as old as the law that no one shall be personally bound, restricted, until he has had his day in court. By which is meant, until he has been duly cited to appear and has been afforded an opportunity to be heard. Judgment without such citation and opportunity lacks all the attributes of a judicial determination. It is judicial usurpation and it is oppressive and can never be upheld where it is fairly administered. 12 a.m. Jure. First, Constable Law, Sect. 573, page 269. Note, this sounds like the process used to deprive one of the privilege of operating a motor vehicle for hire. It should be kept in mind, however, that we are discussing the arbitrary deprivation of the right to use the road that all citizens have in common. The futility of the state's position can be most easily observed in the 1959 Washington Attorney General's opinion on a similar issue. The distinction between the right of the citizen to use the public highways for private, rather than commercial purposes is recognized. And under its power to regulate private uses of our highways, our legislature has required that motor vehicle operators be licensed, IC 49-307. Undoubtedly, the primary purpose of this requirement is to ensure, as far as possible, that all motor vehicle operators will be competent and qualified, thereby reducing the potential hazard or risk of harm to which other users of the highways might otherwise be subject. But once having complied with this regulatory provision, by obtaining the required license, a motorist enjoys the privilege of traveling freely upon the highways. Washington AGO 59-60 number 88, page 11. This alarming opinion appears to be saying that every person using an automobile as a matter of right must give up the right and convert the right into a privilege. This is accomplished under the guise of regulation. This statement is indicative of the insensitivity, even the ignorance, of the government to the limits placed upon governments by and through the several constitutions. This legal theory may have been able to stand in 1959, however, as of 1966, in the United States Supreme Court decision in Miranda, even this weak defense of the state's actions must fall. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Miranda v. Arizona, 384 U.S. 436, 491. Thus the legislature does not have the power to abrogate the citizen's right to travel upon the public roads, by passing legislation forcing the citizen to waive his right and convert that right into a privilege. Furthermore, we have previously established that this privilege has been defined as applying only to those who are conducting business in the streets or operating for hire vehicles. The legislature has attempted, by legislative fiat, to deprive the citizen of his right to use the roads in the ordinary course of life and business, without affording the citizen the safeguard of due process of law. This has been accomplished under supposed powers of regulation. Regulation. In addition to the requirement that regulations governing the use of the highways must not be violative of constitutional guarantees, the prime essentials of such regulation are reasonableness, impartiality, and definiteness or certainty. 25 a.m. Jure. First, Highways, Sect. 260. And moreover, a distinction must be observed between the regulation of an activity which may be engaged in as a matter of right and one carried on by government sufferance of permission. Davis v. Massachusetts, 167 U.S. 43, Packard v. Banton, Supra. One can say for certain that these regulations are impartial since they are being applied to all, even though they are clearly beyond the limits of the legislative powers. However, we must consider whether such regulations are reasonable and non-violative of constitutional guarantees. First, let us consider the reasonableness of this statute requiring all persons to be licensed, presuming that we are applying this statute to all persons using the public roads. In determining the reasonableness of the statute, we need only ask two questions. 1. Does the statute accomplish its stated goal? The answer is no. The attempted explanation for this regulation to ensure the safety of the public by ensuring, as much as possible, that all are competent and qualified. However, one can keep his license without retesting, from the time he/she is first licensed until the day he/she dies, without regard to the competency of the person, by merely renewing said license before it expires. It is therefore possible to completely skirt the goal of this attempted regulation, thus proving that this regulation does not accomplish its goal. Furthermore, by testing and licensing, the state gives the appearance of underwriting the competence of the licensees, and could therefore be held liable for failures, accidents, etc. caused by licensees. 2. Is the statute reasonable? The answer is no.
Whoa, 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 whoa,
This statute
whoa, hold on. Hold up. Oh, that is a good legal point. That's a good legal point across the whole board. If anywhere whoever provides a license, DMV for the people, through the state, doctor, patient, through the board, through the state. So anywhere where they're providing a license, you're under their jurisdiction. And if you mess up, just like if a cop messes up, he's got some liability on there, but he's got some bonds and whatever. They kind of shield him. So that means if you're a normal driving licensed driver, or a doctor, and they can prove negligence or what you did was not accurate, you caused damage and harm or unalive, would then not the very people who provide the license be ultimately responsible because they were the ones ultimately who said, we're going to provide you with this license. You have passed our courses enough that we believe you are good, but in fact, you weren't perfect. So they could be held liable for your damages in your vehicle or people at the hospital when the doctors, you could go after all of them. Lawsuit city, lawsuit city. That's why probably a lot of them want you to have insurance because they want it to hit your insurance before it hits theirs. Or you wake up to know that you could go after their insurance. Also, I like banks have you get insurance over the house, even mortgage insurance. So if you don't make a payment, that's where it's supposed to come from. But also that they have to have insurance over everything that they have. And they all want you to foot the bill on something that they're supposed to foot. Now, I wasn't intending for that little gem drop to come out, but that just hit me as a thought. That in itself is a whole nother level to this game. All right, let's get back to it. Pay no attention to the man behind the curtain. Carry on.
statute cannot be determined to be reasonable since it requires to the citizen to give up his or her natural right to travel unrestricted in order to accept the privilege. The purported goal of this statute could be met by much less oppressive regulations, i.e., competency tests and certificates of competency before using an automobile upon the public roads. This is exactly the situation in the aviation sector. But isn't this what we have now?
Come on.
The answer is no. The real purpose of this license is much more insidious. When one signs the license, she gives up her constitutional right to travel in order to accept and exercise a privilege. After signing the license, a quasi-contract, the citizen has to give the state her consent to be prosecuted for constructive crimes and quasi-criminal actions where there is no harm done and no damaged property.
Which means that they're ultimately responsible. So somewhere in there, they must get us to waive them of responsibility, and then we take it all on ourselves. Wow.
Property. These prosecutions take place without affording the citizen of their constitutional rights and guarantees such as the right to a trial by jury of 12 persons and the right to counsel, as well as the normal safeguards such as proof of intent and a corpus delicti and a grand jury indictment. These unconstitutional prosecutions take place because the citizen is exercising a privilege and has given his/her implied consent to legislative enactments designed to control interstate commerce, a regulatable enterprise under the police power of the state. We must now conclude that the citizen is forced to give up constitutional guarantees of right in order to exercise his state privilege to travel upon the public highways in the ordinary course of life and business. Surrender of rights. A citizen cannot be forced to give up his/her rights in the name of regulation. The only limitations found restricting the right of the state to condition the use of the public highways as a means of vehicular transportation for compensation are, 1. That the state must not exact of those it permits to use the highways for hauling for gain that they surrender any of their inherent U.S. constitutional rights as a condition precedent to obtaining permission for such use. Riley v. Layson, 142 so. 619, Stevenson v. Binford, Supra. If one cannot be placed in a position of being forced to surrender rights in order to exercise a privilege, how much more must this maxim of law, then, apply when one is simply exercising, putting into use, a right? To be that statute which would deprive a citizen of the rights of person or property, without a regular trial, according to the course and usage of the common law, would not be the law of the land. Hoke v. Henderson, 15 NC 15. And we find it intolerable that one constitutional right should have to be surrendered in order to assert another. Simons v. United States, 390 U.S. 389. Since the state requires that one give up rights in order to exercise the privilege of driving, the regulation cannot stand under the police power, due process, or regulation, but must be exposed as a statute which is oppressive and one which has been misapplied to deprive the citizen of rights guaranteed by the United States Constitution and the state constitutions.
All right, I'm going to skip through the taxing power. Basically, they're just saying that they're not supposed to tax any of your rights, and that's why they are converted a right into a privilege, and they tax the privilege because it's within their jurisdiction of the membership. All right, so we're going to skip through that.
Taxing any claim, McCullough, the power, it may, Crandall, and, if the right, Ibid, page 47. Therefore, the right of travel must be kept sacred from all forms of state taxation, and if this argument is used by the state as a defense of the enforcement of this statute, then this argument also must fail.
Boom.
Conversion of a right to a crime.
This is the coup d'etat right here. They cannot convert a right into a crime. So if you have the right to travel, they cannot convert it into a crime, and you do have the right. Matter of fact, some people will argue out there, well, right of travel just means to go from point A to point B, even though we already discussed that earlier. But here's the thing. It does, in saying right to travel, it doesn't say exclusively for public or private. So a right to travel on the roads in whatever demeanor you choose is in fact a right. Because it does not specifically say there is no such thing as a private right to travel. So if it doesn't say that, it can be construed then that right to travel means public or private.
TM, welcome to U.S. Law Book.
Keep doing that.
As previously demonstrated, the citizen has the right to travel and to transport his property upon the public highways in the ordinary course of life and business.
And the fact here that it doesn't say licensed, which means public, thereby then by default means unlicensed and private. Because see, they specifically say on the public highways So sometimes the law is also such as that if it doesn't say it specifically, then they can't say anything against it. If it doesn't say I can't walk, like if you want to be like a dick, okay, I don't know, this is just an example, so it may not even fully make sense. But okay, if they say you cannot jaywalk, well then what if I do a Compton City crip walk? Okay. And then they can't ticket me. Well, what are you doing? I'm crip walking. Well, yeah, but it looks like to me you're dancing across the street, so I'm gonna call it jaywalking. Nope. The law in here in this state says jaywalking, walking like a J. I'm sea walking. See what I'm saying? Not a great example, but you get what I mean. So here, if they're not saying it's public or private, it could be construed to be either.
Business. However, if one exercises this right to travel, without first giving up the right and converting that right into a privilege, the citizen is by statute guilty of a crime. This amounts to converting the exercise of a constitutional right into a crime. Recall the Miller versus U.S. and Sneerer versus Cullen quotes from page 5, and the state cannot diminish rights of the people. Hurtado versus California, 110 U.S. and where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Miranda, indeed.
Abrogate or abridge. You cannot hide. To abridge or abrogate means to go around, circumvent. You're walking down the path, and instead of having a path there, they build a bridge so that you can't get to the water. It cannot abridge your rights. It cannot abridge your access to those rights and freedoms unless you want them and you waive your rights by registering.
Indeed, the very purpose for creating the state under the limitations of the Constitution was to protect the rights of the people from intrusion, particularly by the forces of government. So we can see that any attempt by the legislature to make the act of using the public highways as a matter of right into a crime is void upon its face. Any person who claims his right to travel upon the highways, and so exercises that right, cannot be tried for a crime of doing so. And yet, this freeman stands before this court today to answer charges for the crime of exercising his right to liberty. As we have already shown, the term drive can only apply to those who are employed in the business of transportation for hire. It has been shown that freedom includes the citizen's right to use the public highways in the ordinary course of life and business without license or regulation by the police powers of the state. Conclusion. It is the duty of the court to recognize the substance of things and not the mere form.
There you go. This is huge right here, guys. What did they say? It is the duty of the court to recognize the substance of things and not the mere form. You've got something in front of you that has a form, but what is it made out of? You've got the form of law, but what is the substance of it? Let's break it down. What does this mean on a legal level?
Form. The courts are not bound by mere form, nor are they to be misled by mere pretenses. They are at liberty indeed, they are under a solemn duty to look at the substance of things, whenever they enter upon the inquiry whether the legislature has transcended the limits of its authority. If, therefore, a statute purported to have been enacted to protect the public safety has no real or substantial relation to those objects or is a palpable invasion of rights secured by the fundamental law, it is the duty of the courts to so adjudge, and thereby give effect to the Constitution. Mulger v. Kansas, 123 U.S. 623, 661. And it is the duty of the courts to be watchful for the constitutional rights of the citizen and against any stealthy encroachments thereon. Boyd v. United States, 116 U.S. 616. The courts are duty-bound to recognize and stop the stealthy encroachments which have been made upon the citizen's right to travel and to use the roads to transport his property in the ordinary course of life and business. Hadfield, Supra. Further, the court must recognize that the right to travel is part of the liberty of which a citizen cannot be deprived without specific cause and without the due process of law guaranteed in the Fifth Amendment. Kent, Supra. The history of this invasion of the citizen's right to use the public highways shows clearly that the legislature simply
Right. So we've just covered that ins and out. Now, I'll still be on the troll side for a moment. Like, like, but what? I would completely be on the troll side if I already haven't beaten the courts. Other people have beaten the courts, won their case. The cities, the counties, the whatever back down for me personally. If other people I've taught this to and have used this haven't backed down, do you think it's easy to beat the court? I challenge each and every one of you trolls out there to go and see if you can beat the court on something. Go break the law and see if you can just beat them. See if they ask you after beating them to join them. I have. Other people that I've taught how to do this and exert their constitutional rights have been winning across the board. 500,000, 1.2 or $5 million, and so on. Go beat the courts. Matter of fact, before bothering me, because I'm easy. No, not really. Oh, I guess it can be. Uh, Go do something and see if you beat the court. See if you win. If all that I'm saying is just BS and it's all interpretation, it's not, it's all just, semantics, then why did they let me win? See, they're not letting me win. I'm winning because I'm beating them with something superior, which is the Constitution. It's been around long since before me. But you guys, some of you attorneys and lawyers and whatever else, they'll tell you, oh, well, we just dismissed it because these guys are crazy. It's just easier, it's quicker. They don't know what they're talking about. They use the legality. I just didn't want the headache. Do you think that's really why? Now I see why you're bothering me. Because you're gullible. See, the whole thing here is that if I go in there into court with this information, which they don't even let me in court anymore. They don't like me in there. Not when they know who I am. I'm going to embarrass them. I'm going to ruin their day. And even though they can try to railroad me if they choose to, because they can do that, they can railroad you. They can plow right over you because you don't know how to do. Oh, don't worry. This part will be on my seminars for those people who get that. And seminars, they're coming soon. Black Site 32 seminars page. Don't worry, they'll be worth your time and your money. Some will be free and some will be paid. You have to know how to deal with them and how to do it properly. Because if you walk in there and you're just saying willy-nilly stuff, or you're not saying it the proper way, you're not doing some things beforehand, they're going to run all over you. And why they're going to do that? Because you're interfering with their business day in their jurisdiction, on their lap. They're not trying to have it. You don't know what's going on. You're incompetent. And they're gonna embarrass you. And you're gonna feel embarrassed. And then that's usually when I get a call. Can I do a consultation? But I don't get mad because one, hell, let's be honest, you guys make me money. All right. Two, I haven't made a video for you guys yet, which will be in the seminars, where I break it all down and how to move properly. Once I do, everybody and their mother's going to start copying the video, the materials, and making their own little videos based on them and whatever else, because that's just how it goes. So at least if you're going to do that, at least throw some credit my way in your videos on your channels and whatever else. If I see it or you let me know you did, I'll throw it back at yours. I don't care. I'm not trying to have all the money and the fame and the power. That's not what it's about anyway. So you also have to understand that when you embarrass them in court, And if you prove, see, the first thing is here, you're going to cost them money because if they lose, they have to pay the fees. What do you think the prosecutor and the judge have? Well, you guys probably don't know this stuff. My bad. They have to have their checkbooks ready because they have to bond the case if they lose. The case itself already has a bond, but that's for you. Oh, probably wasn't supposed to tell you that part. But they have to be able to pay those fees. They've made a promise that we are so sure we can close the case on this person. It's a slam dunk. It's guaranteed money. Guess who has to pay if you win? But you also have to come. You also have to beat the judge. You have to convince the judge by beating the prosecutor to say it correctly. But I've seen them choose to do whatever they want to do. So you have to learn how to hold them accountable. And I know how to do that. That's why we've been winning. Now, after that part, it's also understanding that if you give this information out in front of everybody in the courtroom, some of you guys haven't, there it is. If you give out this information in the courtroom, guess what everybody and their mother are going to be saying and utilizing? All the things that you're talking about. So do you think they're gonna let you ruin their day? You don't think they watch these videos? You don't think the department's out there watching my videos? I know they do. I know you guys do. And that's okay because most of you guys are just trying to learn. But then there's some of you guys who don't like it. I get that. I've seen the advertisements underneath there. See, but the thing is that I get information from all over the place, let's just say. I have many connections, many groups that reach out to me, we'll just say. That's all. Same. I know a lot of people. People give me a lot of information. I've also learned a lot of things. And we are about the people. So if this information bothers you or triggers you, you don't like the Constitution or America, then get off of our land. Because you're a traitor. If you are an American and you're operating as one of them and you're against this information, then you are a traitor. And you're treasonous. And look up the penalty for traitors and treason, will you? You get a time instead of bothering me? Just saying. So I get hundreds of emails a day, on people who tell me about their victories, successes, how their lives have been improved, how they have a greater faith in the United States of America now, knowing that America is alive and well in each one of us, but it is dormant in so many of our brothers and sisters across these United States of America. God bless America. Let's go. I'll talk to you guys later. Thanks for watching. Badwolf's out. Stay out of trouble. Don't be a belligerent or combatant. Go in peace, but carry a big stick.